Hello again, it's John Crotts at King Law, attorney and certified elder law specialist. Going to talk to you today about planning to make sure that minor children have a guardian if something happens to both parents. I know most of my videos are on elder law, some about general estate planning. This applies to both uh, because if you ask uh, some of my elderly clients who have grandchildren. Um, Tell me about your grandchildren. Do you have any pictures of your grandchildren? That's always a great way to strike up conversation. Um, and, grandparents love their grandchildren and want to make sure that they're taken care of. So this is appropriate both for grandparents and parents alike. Um, so a great way to make sure that minors are taken care of if something happens to both parents is for the parents to name a guardian in their will. It's what we call a testamentary guardian. Um, so the way that works is by law, if the parents name a proposed guardian in their will, then upon their death, um, the named individuals would still have to petition the court for formal appointment of a guardian, and the court is going to give strong consideration to that nomination by the deceased parent in the will. Um, but that appointment will take effect upon death, subject to the court's confirmation. Um, as long as the nominee is not unfit or unsuitable to serve, then that's likely going to stand up, and the court's going to grant that guardianship. Um, if there's no guardian named in the will, then it's kind of an open-ended decision on who's that guardian going to be. Any interested party, any family member could come forward and apply for guardianship of that child. Um, and the result may or may not be what the parents or grandparents wanted. Um, Maybe one set of grandparents would have been more suitable in the eyes of the parents, but another set of grandparents or aunt, uncle, whomever uh, is who the court ultimately decides they think the guardian should be. So make sure that your children, uh, if you're a grandparent and you have children with minor children, encourage them to get their wills done, to put these guardianship appointments in there. Um, and if for those of you who still have minor children, obviously we want you to get in and make sure that you get your wills updated with the guardianship language. There's different types of guardianship, just like for adults. You've got guardians of the person to make the decisions concerning the minor's physical well-being. You have guardianship of the estate if the minor had inherited money, and you want to make sure that um, the guardian is administering the money, or being a good steward of that money on behalf of the child. Uh, but the guardian is going to have to report to the court and give accountings to the court for any money that would have been directly inherited by the child. There's actually some better ways to do that, to manage money through the wills, through what we call a testamentary trust, where a trustee can administer the minor's funds outside of court supervision, but you still need a guardian for their physical well-being. If the child is 14 years of age or older, the court can actually consider the child's wishes in a guardianship proceeding, um, which, just depending upon the suitability and the maturity of that child, will determine whether or not the court actually follows those wishes. Um, but there will be an inventory and an accounting of assets, as I mentioned earlier, if there's any uh, supervision of money involved. Um, and ultimately the court's going to look out for the best interest of the child in making these appointments, and make sure that their needs are met, and that they're appointing the right person to do that. So make sure that you and your loved ones, if you have minor children, that you meet with an attorney, get your wills prepared, name the guardian. And by the way, if you've done that, or if you plan to do that, maybe you've got a 16-year-old and you're like, well, you know, Johnny is going to be 18 in a couple of years. I really don't need to do that. Even if you name a guardian now and the child reaches 18, then you don't have to redo the will at that point. Once they turn 18, we would just ignore any provisions in a will that apply to guardianship once they reach that age. Still a good idea to have your will reviewed every few years, just to make sure there's no reason to make changes. But this is an excellent reason to make wills, especially um, younger folks with minor children that want to make sure that they're taken care of. And oftentimes, parents are going to appoint their parents, the grandchildren, uh, as the suitable caretakers if they're still healthy enough to manage that responsibility. So if you've got questions about wills, guardianships, or anything of that nature, feel free to call us at King Law, and we'll see you next time.